Former Republican governors filed a friend of the court brief arguing that the former president should not be on the ballot in Colorado. A former University of Montana law professor says Donald Trump should be on the ballot and that the voters will make the final decision. It's been 23 years since Mark Roscoe has held office in Montana.
You can feel the excitement in the air.
But the former two-term governor and former Republican National Committee chair is back in the political spotlight, joining two other former governors from the 1990s in filing an amicus brief to the U.S. Supreme Court, arguing that former President Trump is ineligible to run again for president.
The 14th Amendment, which is very plain on its face, says that if you have taken an oath and sworn to defend the Constitution, and while in office thereafter betray that oath by engaging in an insurrection, then you are ineligible to run for that office again.
Justices are considering whether the state of Colorado can remove Trump from the ballot after that state's Supreme Court last month ruled Trump wasn't qualified based on his actions leading up to January 6th, citing the 14th Amendment of the Constitution, which says no one can hold federal office if they have, quote, engaged in insurrection or rebellion against the U.S.
The Constitution is very plain. It's very clear.
But not everyone sees eye to eye with the former governor. Rob Nadelson is a constitutional scholar and former University of Montana law professor.
I will confess that I haven't always been a great fan of President Trump, but like every American, he's entitled to due process.
Nadelson, too, cites the 14th Amendment, which also says, quote, nor shall any state deprive any person of life, liberty, or property without due process of law. Nadelson now heads the Independence Institute's Constitutional Studies Center in Colorado. He argues the Constitution refers more to something such as the American Revolution and not what happened on January 6th.
They're talking about actually leading the forces or participating in the forces to overturn the government. They're not talking about a speech such as President Trump gave in which he urged his followers to peacefully and patriotically proceed to the Capitol.
The two also disagree on the term officer, which Roscoe says includes the president. Nadelson says at the time when the 14th Amendment was adopted, a Supreme Court justice wrote that the president was not an officer under the United States.
The people who drafted and ratified the 14th Amendment were very familiar with that treatise. And so that's a bit of evidence suggesting that the presidency is not an office that can be disqualified under the 14th Amendment.
He's the supreme officer because he's the chief executive of our government under our Constitution. So there's literally no realistic or credible allegation or discussion about whether or not he's an officer.
It's a debate far from over and one that will now be up to the U.S. Supreme Court to decide.
He cannot pass the qualifications, so he cannot be granted access to the ballot. And if he's not on the ballot, he can't be voted for.
When the people elect somebody president, if there's a charge of insurrection against that person, the people really have heard the charge and made their decision, and the people are the highest political authority.
In Billings, David J., MTN News.